There are two speakers in this panel. I'm not going to be reading long bios just because I like things to run snappy. So the first speaker is Nicole Howell, Esquire, and she's an attorney for Clark Howell, LLP, a founding co-chair of the Psychedelic Bar Association and a board member for North Star Project. And also, it turns out that she was recognized as one of the top 75 most important women in cannabis. So I didn't know that about her, and I'm looking forward to chatting with her later about that. This panel, two-person panel, is on medicines, crimes, laws, and patents. Both people speaking are attorneys. Ms. Howell will speak about the present regulatory landscape and how to shape its future, and shaping the future of regulatory policy. Nicole Howell.
Thank you, Julie. Good morning, everyone. My name is Nicole Howell. I am a human being who practices law as a profession. I have used psychedelic substances as tools in my quest to find out more about who and what I am. And I am a stand-in for the many brilliant, awake human beings, my colleagues in the Psychedelic Bar Association and the North Star Project, who have heard the call to make the business of law and the law of business different, better, and more humane. I'm invited this morning to speak to you about the law of access to psychedelics in the United States. And in particular, when Kevin asked me to speak to you, he wanted you to come away from this morning with a good foundation for how to read the news, how to analyze the news. And those news developments are coming at you fast and furious, aren't they? It seems like the psychedelic renaissance has picked up warp speed, certainly in terms of the cultural attitudes about whether psychedelics and other drugs should still be illegal. And I'm also invited to offer my perspective, which is that we not just be good consumers of news, but that we see ourselves as active agents of change, and that we make better news. So, another way of asking ourselves that question is, are we here to simply bring psychedelics to the mainstream? Or are we wanting to make the mainstream more psychedelic? I hope the answer in this room is more psychedelic. But what do I mean by that? What I mean is that the research shows, and it's our experience, that when we have a therapeutic experience with a psychedelic, there's something else going on there. And that something else is that we have a direct lived experience of a connection to something more than this collection of space and cells that's standing in front of you, something more than what's sitting in your seat. And not only do we feel a connection to that something more, but we recognize that everything and everyone around us is also connected to that something more. Now, whether that experience and the therapeutic effect is causal or correlative, I'll leave that to the scientists, I know better. But it doesn't seem to matter for answering that question, because if we're given the opportunity for that experience, we shouldn't squander it. And it has profound impacts for how we do this thing, how we legalize, how we regulate, how we commercialize, how we deliver. So now, if I ask you this question again, by a show of hands, who here is for just bringing psychedelics to the mainstream? Don't worry, we won't shun you for long. And who here is for making the mainstream more psychedelic? Yes. All right. Whew. That could have gone wrong. I'm going to press my luck here, and I'm going to ask you to make my Horizon presenter dreams come true. And could we all together, all at once, out loud, on the count of 3, say, more psychedelic? Can we do this together? Okay, 1, 2, 3. More psychedelic. I mean, I could seriously die and I'd be so happy. Thank you so much. But I do have some more time, so let's talk about the law. Okay, next. All right, so Psychedelic Law Reader, December 4, 2021. Let's see what our top headlines are. Next. The war on drugs, mission accomplished, question mark? Nope, back. Thank you. The so-called war on drugs has proven to be a very successful war on people, a very effective tool in the entrenchment of systemic racism, and a boon to the prison industrial complex. Next. So our friend and foe, the status quo. Next. All states and the federal government punish possession, not Oregon, we'll talk about that in a moment, production, distribution, and sale of non-prescribed psychedelics as crimes. Next. How did we get this war on drugs? Next. 1970, President Nixon signs the Controlled Substances Act. By this time, we have all heard or read about his advisors' quote that they were totally lying to us about drugs, and that in fact the Controlled Substances Act was designed to disenfranchise, quote unquote, the blacks and the hippies. Controlled Substances Act, rotten at its core. Next. 1984, we get the Sentencing Reform Act, which gives us the federal sentencing guidelines. I brought this morning volumes 1 and 2 of the federal sentencing guidelines. There is also a volume 3 and a manual that's about this thick that I used in my days as a federal defender. The thing to understand about this is that this was designed to make sentencing more just and more consistent across the board. It seems like a good goal, but what we ended up with is a Byzantine set of rules, and the way that we decide how much time people spend in federal prison is a matter of calculating points. And at the front of this manual is a chart. At the top of the chart are criminal history points. You get criminal history points for convictions, incarceration, probation, parole, violations of probation and parole. When you live in a very over-policed neighborhood, it's very easy to rack up criminal history points. Down the side are your offense category level. For drug crimes, this is all based on the quantity of drugs involved in the crime. Now, how do we do that? How do we standardize that across types of drugs? Well, in their infinite wisdom, the federal government came up with a drug equivalency table. Has lots of bias in it. I'll give you the most egregious of those, which is that in 1984, the powder to crack cocaine disparity was 100 to 1, which means that you had to have 100 grams of powder cocaine to get the same sentence as someone with 1 gram of crack cocaine. Are we punishing harm there? What's that? What are we up to there? Next. 1986, our bloodlust for mass incarceration will not be quenched. We have to have mandatory minimum sentences in 1986. So these are mostly for drug crimes, minimum sentences for even low-level offenses that judges were not allowed to depart below. Next. In 2010, we finally get some relief from this. President Obama signs the Fair Sentencing Act, which reduces but does not eliminate the crack powder disparity from 100 to 1 to about 20 to 1. Still in the law today. Next. So today, the upshot is basically all psychedelics, heroin, cocaine, methamphetamine, they are all still crimes punishable severely. Those guidelines would make Foucault blush. Police and prosecutors still have discretion, these quantity disparities still exist, and criminal history is still an adjunct for systemic racism. Next. All states follow suit except Oregon, which we'll talk about in a moment. Okay, what's next on our newspaper? Real-life access. So how are people accessing psychedelics? Next. So in real life, we're kind of in two ways. Next. Illicit use. Next. Versus, next, narrow legal access. So, next, illicit use, we have what we call in the wild, right? So, in the wild with or without a guide. Lots of people are turning to guides. Because there's no law around the use of guides, we have no state-enforced rules about licensing or ethics. That leaves open a lot of room for problems. Oregon's system won't go on until 2023. You'll hear a lot more about that this afternoon. Next. And then we have ceremonial use. So this is where people sit with plant medicines, with guides in the Amazon, here in the States, guides that are trained and come from a history and a lineage of indigenous use with music and ceremony. You are not safe from arrest or prosecution or seizure of your medicine without a legal adjudication. So as my colleague Ismail Ali says, your retreat center is not a religion. Okay, your retreat center is not a religion. Ayahuasca is not deemed to be a sacrament just because you use it. We'll talk a little bit more about that in a minute. Versus there's some narrow legal access. Next. So there are a few legally recognized religious use exemptions under a law called the Religious Freedom Restoration Act. There are really only 3. 2 of these were churches that were granted an exemption that use ayahuasca as a sacrament, and the other is the Native American church that has an exemption for the use of peyote. Next. And we have medical use. These are the ketamine clinics that we know about where physicians prescribe ketamine off-label. Next. And there is one FDA-approved drug that is also prescribed by a physician. This is the esketamine nasal spray. Next. All right, what's next? All right, so under current law, if nothing changed, what are the pathways to opening access? So our headline here says you either go to court or raise about $1 billion. Next. All right, next. Okay, so private plaintiff. Private plaintiff says, court, I've been impacted, I've been damaged, make it right. That plaintiff goes to court. If that plaintiff is successful, it sometimes opens access for a group of similarly situated people or paves the way for case law to allow that expanded access. We call that impact litigation. In the psychedelics context, we have kind of 2 avenues. Next. Religious use and next. And for terminally ill and dying patients. So in the religious use context, next, there's a sort of absurd path through the DEA where you can apply for an exemption. It's nearly impossible for it to be granted. But you can apply for that DEA exemption, get denied, and then appeal to the courts and sue for relief. There's been one example of that. An organization called SoulQuest went that path, and the federal courts ruled against them and ruled on the side of the DEA. So that path in that case was not successful. Next. The other litigation avenue is to show damages, and in this case, that's to have been arrested or have your medicine seized. And to sue the DEA, or not the DEA, to sue the federal government saying that the DEA has illegally restrained your use of your exercise of religious freedom. This is a very long and expensive process, both to the pocketbook and the soul. Next, for terminally ill and dying patients, under both state, next please. Under both state and federal law, there's something called the right to try. So the state and federal government say that if a terminally ill or dying patient and their physician want to use an experimental drug to help ease the pain associated with the end of life, they should be able to do that. In this case, the DEA is getting in the way. My colleague Catherine Tucker has brought this case in the Ninth Circuit, Ames versus DEA, to ask them to stop doing that. Next. Next. Then we have the drug development path. So the FDA approval path. You've heard lots about it already. You're going to hear more. I'm going to cover it very briefly. So there are a few different avenues. Next. There's something called the breakthrough therapy path. This is a slightly accelerated path to get to FDA approval. It's only available for serious and life-threatening illnesses. The example is that nasal spray that was approved by the FDA. It's approved for use with major depressive disorder, with suicidal thoughts or actions. So they made their way through that. Breakthrough is a little bit of a misnomer because it connotes that there's something extra special about it. It just means that it has on a shorter path. Next. There are a couple other accelerated paths to the FDA called fast track and priority review, kind of what they sound like. The FDA decides whether you're eligible for that. Next. And then there's the full approval path. Could be years to decades, depending on what we're talking about. And data shows that it's upwards of about $1 billion. Yes, that's with a B, in order to get one drug through the FDA approval process. However, the shining exception to that seems to be MAPS, which I heard a statistic yesterday that they may get through that with about 170 million, which is a fraction of $1 billion. So I'll leave that to Joe to talk to you a little bit more about that this morning. Next. So then, the question here when we're talking about these drug development companies that we've been talking a lot about at this conference, and I'm so glad to hear it, as so many of us are, is what are our priorities here? Are we profit first or public benefit? So there seem to be two paths kind of emerging here. Next. We have the open science and treating IP sort of as a commons. My colleague Graham Pechenik, who's going to speak to you next, will talk more about that. These are non-profit or purpose-driven companies. They have governance structures that include stakeholder and stewardship capitalist models versus, next, the sort of land race that we're seeing in intellectual property and patent. Lots of public companies traded on the NASDAQ and the Canadian Stock Exchange that use terms like this one. I pulled this directly from the pitch deck of one of these companies. I couldn't miss the opportunity to show you these. So strategic competitive moats was one of the pages on that. So these are the two approaches right now. Next. Next, please. And next. So that's the way that we can get, those are the few narrow ways that we can get things done through the current law. So how are we changing laws? Next. We're doing this in a few different ways. So these are cities and states making moves, right? So let's start with city initiatives up here at the top. So these are those, you can go next, please. So these are cities demonstrating changing public opinion. So these are what you have heard in the news referred to as decrim bills in Denver, in Oakland, in Ann Arbor, in Washington, D.C. These really are deprioritization measures. Next. So it's not truly decriminalization because they haven't removed the substance actually from the statute. What they have said is, police and prosecutors, we want you to make prosecution of personal use possession the least important thing that you do. If there is literally anything else happening that day, we want you to do that first and not worry about possession of psychedelics. These are really important in that they have educated the public. These campaigns have truly educated the public about psychedelics. They are great bellwethers of public opinion, and that public opinion really is changing. And it's also given people in this arena to really have an opportunity to get involved in the democratic process. These are people really making news, making headlines. But it's important to know a few things about them, the nuances and some of their limitations. Next. Peyote was included in many of these initiatives against the position of the Native American Church. Go find out more about that. Next. As I said, possession still technically on the crime. It's still technically a crime. These city initiatives don't change state law. Next. And likewise, the supply side, production, distribution, sale, all still crimes. Next. Police and prosecutors still have wide discretion between what's possession with intent to sell and what's just possession. You can see how that can be with discretion disproportionately enforced. Next. Next. Then we have decriminalization of personal use possession. Next. This is where we've actually removed it from the law. Next. Oregon Measure 110 is the only one, no longer a jailable offense to possess small amounts of drugs. This law includes heroin, cocaine, methamphetamine. Next. Does not legalize or regulate access. Again, this leaves a huge amount unanswered. If possession's legal, but accessing it and making it is not, there's a lot more work we need to do here. Next. Next. And then we have full decriminalization, which includes legalization and regulation, where states actually license the access points. Measure 109 in Oregon is the only one to do this so far. That will go online in 2023. Next. And this is really where we have the opportunity to make sure that we have safe, affordable access. Next. This is where we can require integration services. Next. This is where we can prescribe ethical business practices. Next. And we can ensure that these are affordable and that insurance covers them. Next. 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 So where does this leave us? Next. Well, we've learned that the drug war has to go. We've learned that people are breaking laws to access these medicines. We have learned that there are very narrow legal pathways right now that are very expensive to human and financial capital means, and that there is so much work to do. There are so many questions left unanswered that we must answer. So I hope that you feel a little more informed about the law, and I hope you feel a lot more inspired to take responsibility for what's possible. Because psychedelics can show us more about who and what we are, but ultimately, it's up to us to act like we know that's true. So let's make different headlines, better headlines, headlines that are more just, more equitable, more reflective of the truth of our interconnectedness. In other words, more psychedelic. Thank you.
Very much enjoyed that. Next. Next is Graham Pechenik, Esquire. He is a patent attorney. He is the founder of Calyx Law and a contributor to psilocybin alpha, which is something I've been getting in my inbox happily. I'm really trying to follow the whole patent situation. Oh, one quick aside, the issue with peyote is that it's being over-harvested. Synthetic mescaline, that would be something to maybe put some attention toward. Graham is going to continue speaking in the medicines, crimes, laws, and patents section of today, and his talk is about, can we have a psychedelic patent system? Graham Pechenik.
Well, thank you, Julie, and thank you, Nicole, for that great presentation and teeing up a few of the things I'll talk about today. So, as you heard from Julie, I'm a patent lawyer. I studied in undergraduate cognitive neuroscience and biochemistry after being inspired by my first psychedelic experiences. And then I went to law school not too far from here at NYU, and spent the beginning of my career doing patent litigation for big pharmaceutical companies, basically helping those pharmaceutical companies to extend the patent monopolies and keep their prices up on drugs in a way that I think incurred some karmic debt that hopefully I can pay back through at least a little bit what I'm going to talk about today. Besides being a patent lawyer, when I'm not at my desk, which regrettably isn't as much as I'd like it to be, I also volunteer as an interpretive ranger at Muir Woods, which is about 500-acre, some people have been here, have been there, okay. It's about 500 acres of old growth redwood forest just north of San Francisco. And I put this picture up in part because I'm horribly nervous public speaking, and I thought this would remind me to take a deep breath and relax. But also because I think there's a lot of resonances between the ecosystem of Muir and the ecosystem that's developing in the psychedelic space. Muir Woods and the land around it for millennia was lived upon, inhabited, and stewarded by the indigenous Coast Miwok. After the European colonialists came, they were forced off their land, and slowly the diversity and the ecosystem of Muir Woods and the area around it became really out of balance. We saw the largest predators, the black bear, hunted to extinction. We've since learned that actually the black bear helped to recirculate a lot of nutrients and fertilize the trees, even just by bringing fish carcasses up into the areas of the woods. We saw the big deadwood, the snags, all cut down and taken out, even though they were the homes of most of the other animals that lived in the woods. And the stream that ran sort of meandering through the park to keep it from overflowing its banks from time to time, the sides of the stream were sort of covered with concrete, and the stream was made straight, so it would run straight from the watershed all the way to the beach. And in doing so, it eliminated all the habitats for the animals that lived around it, and the tens of thousands of salmon and steelhead trout that would swim up every year and that sustained the Coast Miwok when they lived there have basically vanished. All this in the name of order and efficiency. And so when we see the ecosystem developing in the psychedelic space today, these are things to look upon. I think it's also, not to mention, speaking there as an interpretive ranger, the questions I get most often are about how tall the trees are and what was John Muir's role in saving the woods. The answer to the first, the trees there are actually not very tall at all for redwoods, and John Muir played almost no role whatsoever in preserving it. It was preserved actually by a woman named Elizabeth Thatcher Kent and a group of women suffragists that haven't been very much mentioned in history until recently. And so, what does this mean for the psychedelic ecosystem and patents? Well, you heard some from Nicole that patents have been controversial and their role in the ecosystem is fairly controversial. This is just sort of a grab bag of article headlines over the last year. Articles that raise the issues of what patents mean and what the impact patents might have on the emerging psychedelics ecosystem. And so that's what I'm here really to talk about. And it's a lot to try to get into 20 minutes, and so I apologize. I'll probably go through some things very quickly, and some things I won't touch on nearly as much as with the attention they deserve. But hopefully in question time, we'll be able to get to things that people have more interest in. But at least to try to touch on what the controversies are and what some ways forward might be. So maybe just to start, what is a patent? A patent is a government-granted right, a temporary monopoly. It's a right to exclude for a period of roughly 20 years. And the exclusion is for anybody else making, using, and selling the invention. The patent itself is a document, often hundreds of pages long. Most of the document is what's called the specification, the written description, and then it ends with a page or two of about 10 or 20 claims. And the claims are basically the property boundaries that define what the invention is. And there's 10 or 20 of them because, unlike real property, it's in an abstract sort of space, so there's sort of a variety of different ways one can define what the invention is, and oftentimes define them in a few different sort of alternative forms. And why do we have patents? So the right to grant patents is given in the Constitution in something called the Progress Clause, and promoting progress is really what the purpose of the patent is. So it's meant to be a reward or inducement for that inventive activity to take place. And I want to stop here for just a second because this, I think, is really one of the most important things to understand about patents and the patent system. So patent is the creation of society. A patent was called this to really distinguish it from real property, which was considered to be a natural right, that the government only stepped in to sort of protect you from having somebody else take it from you. And we can question that as an aside, but the patent is meant to be really a social contract between the public and the inventor, and it was meant to be given in a way that the public got a benefit from it, and in doing so gave up that temporary monopoly, that right to the inventor. And so I won't go through all the requirements of what it takes to get a patent, but they all basically reflect this bargain that the public is giving. So the invention has to be novel, it has to be non-obvious over what came before, it has to be useful, and that application, that specification must describe it and enable it in such a way so that anybody reading it can make and use that invention. So that's what the bargain is. So for purposes of the inventor basically investing in something that maybe wouldn't come to the public otherwise and disclosing it to the public, they then get a right to make basically monopoly profits on it in exchange for a period of time that should enable that activity to take place. So how does one actually get a patent? So to get a patent, it's a negotiation between the patent applicant who submits that application and an examiner who basically examines it on behalf of the public. An examiner in the US, the United States Patent and Trademark Office. And the way this takes place is really that the examiner looks for prior art that's out there, basically what the state of the art is, what the application and the claims of that application have to be seen as novel and non-obvious over. And then there's a negotiation that takes place, sometimes 2, 3, 4 times back and forth, written forms that go back and forth, often telephone interviews, to determine whether or not those claims are in fact novel and non-obvious, and where they're not, to narrow and amend them to avoid anything that's in the prior art. The problem with this, though, and this is a statement from one of the very many patent reform acts that have tried to create a better system where patent applications get granted that aren't, in fact, covering anything that's in the prior art, is that patent examiners are burdened with many applications and they have to move very quickly. And in doing so, they often also don't have access to the prior art that they would need. And so many applications can get granted that are overbroad and claim things that are already in the prior art. It's basically taking things out of the public domain, and in doing so, not giving the public what the public is deserving for purposes of getting that temporary monopoly. And the effect of this can be dramatic. We can obviously increase prices because the patent monopoly enables the patent owner to raise prices to monopoly rates. It can deter competition. It can deter the technology being used by others and additional R&D. And of course, the result of this is it can harm consumers and businesses in the economy. And so fixing for these low quality patents is something that's been a problem really for decades in the patent system, but something that's a particular problem in the psychedelic space because of the fact that the prior art, generally the way the patent examiners view it is prior patents that have been filed. And because psychedelics have been illegal and haven't been in patent applications as much until recently, there's not a lot of that prior art to go by, and there's also not a lot of prior art that the patent examiners have in their typical places that they look for it. And so ways to solve for these low quality patents, one of them is just to make that prior art more available, just generally. And we'll hear later from USONA, a project of which is Porta Sofia, that's trying to make that prior art available to examiners. Another method is just to submit prior art specifically into a single application. If somebody knows of an application that's out there that's trying to claim broadly that might harm somebody because it's covering something that people are already doing, it's possible to submit prior art into those applications. It's also possible to challenge applications after they've been granted. And we often hear that the ability to challenge a bad application is really sufficient to weed out these bad applications. And of course, applications are so bad that more than half of drug patents, if they're invalidated, if they're challenged, they end up being invalidated. And the court sort of sarcastically has commented that the only patent that is valid is one a court hasn't had a chance to get its hands on. So this does seem like this would be a reasonable solution, but for the fact that challenges can be hundreds of thousands of dollars or perhaps millions of dollars if they're challenged in court. So this puts it out of the hands of most people. And so some of the applications that we might be familiar with if we followed some of these articles that I put on the first slide, some of the applications covering elements, for instance, of set and setting, of room design, of psychological support provided during psilocybin therapy, psilocybin polymorphs we've heard of. And just maybe the easy question to ask could be, what about just the number of patents on psychedelics generally? Would these number of patents decrease? And so this is just a representation. These are actually graphs of the number of patent applications and patent applications granted, the two different colors, for 4 different compounds. And we can see since about the year 2000, they've increased in extraordinary numbers. So if we were to eliminate low quality patents, would these patents go down? This number of patents go down? Well, the answer to that, I think, is actually no. And so just solving for low quality patents is not going to be enough. And the reason for that, and here, of course, is just why we might think psychedelics couldn't be novel, not obvious. We know they've been used for many years, but also synthesized and sometimes even patented decades ago in the last century. But there are many strategies, and actually the pharmaceutical playbook really is to file patent applications on known drugs. And this is a way, and this is the way that I participated in when I was working for the pharmaceutical companies, to file many different types of what are called secondary patents on known compounds. So the known compound itself, of course, can't be patented, but there's all different types of forms of ways that people can get applications on these known drugs through these secondary patents. And so as I mentioned, this really is a pharmaceutical playbook. More than 3/4 of patents on drugs are for already existing drugs. And many drugs have hundreds even, but tens, dozens of patents granted on them, which extends this patent exclusivity period, this temporary monopoly, beyond the 20 years that it's supposed to be for, sometimes even more than double. And so this is often referred to, sometimes you'll hear as patent thickening or evergreening, but the result of all this is in the United States, where abusive patent practices like this are at their most extreme, we see higher prices, incredible profit margins for big pharma, and that might be fine if we were getting innovation out of it, but major therapeutic innovations are actually a very small percentage of new drugs. So this isn't actually a bug, but this is really a feature to the pharmaceutical industry. This is a slide from McKinsey that says one of the drivers of the golden times of sort of the pharma era was the fact that this successful Me Too patenting, new drugs with limited differentiation, this was something that actually the pharmaceutical companies saw as a real advantage, being able to file these incremental patents, extend patent monopolies, not have to put all that money into innovation, but still reap the reward of the patent. So one just sort of concrete example that many people here might be familiar with, of course, is Spravato. So generic ketamine, you know, it's a racemic mixture. Basically, this one compound occurs in what are often called like left and right-handed enantiomers. Spravato is the left-handed enantiomer. Of course, generic ketamine was off patent, could no longer be patented itself very easily, but the S-ketamine, the left-handed enantiomer, was able to be. And so I won't read through this whole quote, but this is just calling out the fact that this is really a result of these perverse incentives. And you know, I think if people are familiar with S-ketamine, you know, it's obviously more expensive. It's provided generally without accompanying psychotherapy. And you know, there's other dynamics at play here too around reimbursement and other things, but you know, I think Rick Doblin says most pithily, you know, it's a good example of profit maximization rather than maximizing patient outcomes. And that's really what the patent system itself is sort of designed to do. And so I'll kind of jump quickly through this, but just, you know, when I mentioned that the patent system is a creation of society, there are other societies that have found ways to balance the incentives better than we have. So for instance, in India, certain inventions are not considered to be novel. So these include polymorphs and isomers. In fact, a crystalline polymorph of a cancer drug was invalidated on these grounds. And so if we look at things like esketamine or psilocybin polymorphs, in some other countries around the world, they actually wouldn't be considered novel. And this was fairly standard around the entire world until the WTO in 1995 put a treaty called TRIPS out, which was very much lobbied heavily for by pharma, and particularly Pfizer as the US trade representative. And before then, almost all countries around the world had a different way of balancing the sort of incentives around drug patents. And most countries, including a lot of countries in Europe, didn't have drug patents at all, or only allowed them on manufacturing processes, or had shortened patent terms, understanding that public benefit was also at play here. And so patent quality is not necessarily the only problem we have to deal with in the psychedelic space with patents, but also just questions around patent policy itself. And so if we want to fix our patent policy, well, we can create legislative fixes to the patent law, or perhaps the FDA regulatory law. And these are, I'm sure this is an ambitious audience, but these are really, really big asks, especially with the pharmaceutical companies sitting on the other side of these questions. However, there are other ways to really get involved, and I would invite people, if they're interested in these issues, there's some great organizations. One of them is IMAC, the Initiative for Medicine's Access to Knowledge. There's also one called the Coalition to Prevent Abusive Patents. And there's a lot of other ways for sort of smaller incremental changes that we can make to the patent laws. I mean, one of them, for instance, is just, you know, the membership of the Patent Public Advisory Committee is something where people have more influence in being able to say who's on it. Right now, who's on it? The General Patent Counsel for Eli Lilly, a patent lawyer at Facebook, and nobody that really represents the public, despite its title as a Patent Public Advisory Committee. And so there's ways of getting more involved as we can see the patent system as being really the creation of society and having more influence in it, or trying to have more influence in it. But even just fixing pharmaceutical patent policy, what about the fact that the psychedelic space maybe is a little bit different even than just pharmaceuticals at large. And so, some problems just with the patent system itself may need to be addressed. For instance, strong patents, even when they're filed on things that are very innovative, are beyond just a merely incremental advance, they often tend to really hinder innovation developing until those initial early patents expire. A really good example is actually the Wright brothers. So the Wright brothers, they got some really early patents on the airplane. Instead of continuing to innovate on the airplane, instead of allowing others to continue to innovate on the airplane, they basically sued everybody else who was trying to make airplanes, didn't do any innovation themselves, spent all their money on litigation. By the time World War I rolled around, the US actually had such a backwards airline or flight industry that they had to rely on European planes and come in and basically render unenforceable all the Wright brothers' patents. But this is pretty typical, because this is really the way that the patent system is supposed to work. It's designed for this type of profit maximizing behavior. And so I know I have only a few minutes left, and some of the most important slides I probably shouldn't have saved to the end, but beyond just the fact that, of course, some of these drugs are known and used, their use comes from millennia often of traditional use and indigenous use. And even drugs like MDMA, which are new, they were inspired by the use of traditional medicines. And as well, the way that they're used and the psychological and kind of container that's put around them is also inspired by this traditional and indigenous use. And so this raises some questions about reciprocity, which I'll get to on a further slide, but also, should psychedelics really be patented at all? I mean, this is a question that we can raise. And one thing here, maybe so I can end with a little bit of humor. So somebody called patenting ayahuasca like trying to patent a communion wafer. Well, a couple nights ago, I did a search for communion wafers. There's actually over 50 patents on communion wafers. If you're eating a low-gluten communion wafer at your church, you might be infringing somebody's patent, unless you're paying royalties for it. So maybe the patent system itself is fundamentally flawed. It has these design features really optimized for profit maximization. It really just tends to valorize individual effort, these sort of the mythical kind of romantic idea of this lone genius inventor at his workbench. It doesn't recognize the sort of collective and cumulative effort that go into a lot of the work. And so what can we do about that? So, a few things we can do is, just kind of call upon companies themselves to be ethical. And there's a lot of good examples of this. The Thursday Business Forum, a lot of people talked about this, and so there's a lot of optimism in the space about ways that this can be done. We can also just reimagine our interactions with the patent system itself. So the patent system is designed for profit maximizing, but it doesn't have to be used that way. So there are ways that companies can use patents to actually enforce ethical norms and to help transmit those ethical norms to others. We can also rely on incentives outside the patent system. So of course, MAPS is relying on data exclusivity. There's also this concept of delinkage, which is trying to get the sort of payment that comes from the patent monopoly away from being the incentive for especially pharmaceutical drugs, but using things like grants and tax credits, because of course everybody wants to have more access to medicines, more access to cheaper medicines, things like pay for success contracts, crowdfunding. Now it's actually quite a big thing in the sort of blockchain crypto space. People are trying to find ways to fractionalize IP onto tokens and use that to raise money. And so, just kind of like real world, like, is this something that can work? Well, so MAPS, as I mentioned, as we've seen, is using an anti-patent strategy, is not pursuing patents. USONA, who we'll hear from later, is committed to an open science approach, so they're also not filing patents. And then just kind of to leave, going back to Muir, besides, of course, the flaws, it's a really incredibly special place. And part of the reason it's like that, and part of the reason that sort of sets it apart from the whole rest of the coast of California, which all used to be old growth redwood, up to 50 or 100 miles inland from the coast, is this very unique geography that it has. It's in these two very deep, very steep canyons, and it was protected from all the logging equipment being able to be driven down into the canyons to cut down the trees. And so, besides the fact that, of course, Elizabeth Thatcher Kent and others spent a lot of work protecting it, it was also protected just by this natural topography. And when we think about the psychedelic space, I think we often think about the sort of the fact that they're currently still illegal. We think about the stigma as these barriers that need to come down, and of course they do, but what they've also provided us is a little bit of insulation from the broader pharmaceutical sort of industry incursion, from the fact of the use of patents being used negatively, and they've given us a little bit of buffer to really think as we see those barriers of illegality and stigma come down, how we want to use patents, if we want to use patents, if we want to pursue a more open science approach, and if ultimately we want to see the patent system being what it is intended to be, which is the creation of society.
So I would like both Nicole Howell and Graham Pechenik to please come back to the stage and grab a seat and this microphone. So we have microphones for questions, and we have wranglers who are going to help you formulate a question. The microphone is there. I see Christy is already ready to be wrangled. The point of curating questions is just like the point of curating this conference. It's all about sort of signal to noise ratio. Questions aren't telling us about your business or your experience or your dreams, but rather questions. Christy, did you have a question, or are you the wrangler? Christy Strongman is the wrangler. I like that. It couldn't go to a better person. I'm going to ask questions until people get brave enough to come down here and ask their own, but I really recommend if you have anything you would like to ask. Actually, a lot of the things that I wanted to ask you, Graham, you covered, which was great. And I really enjoyed both of your presentations. I was very happy to hear what you have to say. Nicole, when you were talking about impact litigation, it reminded me of something I did a very long time ago, which is that I worked with Graham Boyd from the ACLU. We sued John Ashcroft, Attorney General, for this guy's right to go to dance with glow sticks, because the glow sticks had been considered a drug paraphernalia in the rave culture. And it probably won't surprise you to know that we won. Which paved the way for everyone who wants to dance with glow sticks, that you are free to do so. You're welcome. It was funny because when they were interviewing me, when they were questioning me on the stand, they had a copy of my book, Ecstasy, The Complete Guide, a nonprofit book where all proceeds fund MDMA, PTSD, therapeutic research. So I thanked them for funding clinical research with MDMA, so that was fun. It's like, oh, you bought my book. Thank you so much for supporting our research. That wasn't my question. But you mentioned the right to die litigation and AIMS, the AIMS Institute. I was wondering, first of all, is that Sunil Agarwal, or is that somebody else? Graham's nodding his head, yes. I was curious about that particular thing. And then the other thing I wanted to ask you is there this idea of a breakthrough status, but you also mentioned fast track or priority review. What's the fastest? And is there a way to get bumped up if you really feel like they should hurry more? Microphone 1, I believe, is what do you have number 1?
I have number 1. There
All
we
right.
go.
That's the one that's supposed to work.
So now they're all working.
Well, we can give the other one to Graham, I guess, if they're both on. Okay, never mind.
I forgot the question.
I know, I was just going to remind you. I mean, I almost did, but I totally get that.
Oh, no, I remember now.
Is there
FTA.
something, like, is breakthrough the fastest, or is fast track priority review any faster?
You know, I'm not an FDA lawyer expert, so I may not be right about this. But based on my research, breakthrough I think is the fastest. The other, I couldn't really, frankly, tell the difference exactly between fast track and priority. You submit an application that it should be fast tracked, and then the FDA decides whether to accept that. And from what I can tell, it accelerates the initial evaluation of the initial application. It can shorten it from like 10 months to like 6 months or something. Breakthrough therapy, I do know a little bit more about that, which is that in terms of, full FDA approval requires all full clinical trial. It's the full scientific method to prove, causation. And the breakthrough path allows an analog to that, whereas like if the drug is to treat a particular condition, rather than waiting for the clinical research to prove that it treats the condition, indicators that it treats analogs, like for example with a cancer drug, if they haven't quite gotten through all of the clinical research to prove that it cures the cancer, but they show that it shrinks the tumor, that can be enough for a breakthrough approval to go through. So that's really the difference there, and there are something called REMS, which are the, I forget exactly.
Yeah, I believe we're going to be speaking about REMS a little later, and my assumption is they were also covered on Thursday. I guess we do have questions on the floor, so please state your question in the form of a question.
Hi. My question is, what is your vision for how to balance the needs to generate income and get patents for psychedelics so we can fund research and get through FDA approvals, which is very expensive, versus the balances of keeping the prices low for equity? So I just wanted to hear if you had any visions.
And who is your question for? Which or
just
both?
Both of you guys, yeah. I think both would.
And can you speak into the microphone and make a more concise version so we can answer it?
Okay. I said, what is your vision for balancing the needs to generate income off of psychedelics to be able to fund research and also to be able to get through patents, and also, the need for equity? So how do you see that going? The need for, low cost treatments. So it just was kind of, you see if you had like a broader vision of how that might work.
We'll let each of you give us your global vision of how to balance the money people want to make and the health care that people need. Oh, see?
Turns out I do need a microphone.
Okay.
No, that is a very good question. Thank you very much for that question. And if I had a very good answer, I would have included it with my slides. I can probably put some signposts down, things that I think I touched upon in my slides. So, for instance, there's an enormous imbalance between the amount of profits that pharmaceutical companies are able to get and the amount of innovation that they provide. So I think there needs to be a way for that balance to be brought back to level. So if companies are able to get the incentive to, it's on?
Can you guys hear him? Can you hear? Okay, so speak up, because I'm looking to see if people can hear.
Now I'm on it. Oh, now I'm very much on.
Yeah. Now.
I can start over.
Sorry, sorry, Graham, you're done. No.
So what I was starting to say was that there needs to be balance brought back to the patent system. So as you could see, the amount of innovation that the patent system is encouraging is actually quite low. And it's really encouraging innovation in ways to find just a sort of minimal amount of incremental innovation necessary to extend the monopoly. It's really about finding ways to innovate in making profits and making money, and not in bringing life-changing or really health-changing innovations to the public. So there needs to be some way to bring that back into balance. And I think that can be done in a way that still encourages innovation to happen. And whether that happens through the patent system or through an alternative system of incentives, that's something that's probably open for people to experiment. And I think there are experiments going on right now to find ways to get around the patent system. And those things, I'm excited to see how they progress. Whether or not equity can be built in, so equity if we're speaking about reciprocity or if we're speaking about other ways of providing equity, those are things that the patent system doesn't really have as built in to it, but there are ways of using patents to provide that. So through patent licenses, through some of the things I just briefly touched on, patent pledges or patent commons, either an individual patentee or groups of patentees can come together and put teeth into the ethical prerogatives that they have by using the patent system to do that. And it's probably a technical answer, but it's there, and I'm happy to talk about it more, maybe offline.
And I'll just give a real short answer, which is that I think we need to find different money to fund these companies. Let's not just look at the venture money, because they are in their DNA want to return profits on a 10x. So let's just find different money. That's one of the things that came out of our business forum on Thursday, is that there's other better money to be used to fund these companies. I could say so much more about it.
Yeah. I have a quick question. Like, is there any precedent for multiple groups coming together to argue against somebody else's patent, as opposed to just one company or one organization? Is there any precedent for people teaming up to argue against somebody else's patent?
Yeah, I mean, so that often happens actually with big patent cases that go before the Supreme Court. So a great example would be the Myriad case around the breast cancer genetic test, and dozens, I think, of different civil society groups and other groups who were affected by it or saw it as being really a travesty to the ability to provide genetic screening and be able to provide cheap genetic screening, came together and submitted legal briefs, amicus briefs, before the Supreme Court. And
Okay.
so that's one avenue, I guess. I don't know if that was the avenue you were.
Okay, yeah, no, so there is precedent. All right, so we want to take some more questions from the audience. I don't know how much time we have, guys, so somebody let me know. 3 minutes, very quickly, sorry.
I'll make this pretty quick. Sorry. My question is that open source, while beneficial, can actually take away rights from indigenous groups. How do you see that patents may be instead used and given or written by indigenous groups to protect their rights to these items?
Well, I'm aware of one strategy, at least in a company that was planning to pursue the patent avenue and to turn the ownership of that patent over to indigenous groups. So there's one example.
Let's take another question really quickly.
Yes, for Nicole. Many people who use psychedelics don't know how safe to feel when talking honestly about their experience. They'll say something like, I use psychedelics, but for legal purposes, let's only talk about when I use them in Peru. Could you talk about how people should navigate this intersection of the fear of criminality and freedom of speech?
Nicole.
I mean, it's really a personal decision about whether you want to be out about it, but we're all here to support you. And, I really think that cultural attitudes about this are really changing rapidly. I don't know how to advise you specifically. I feel comfortable talking about it now because of where things are, but I understand if you're not.
Can we do one quick question? I know we said that was the last one, but I see Marcina there, and I feel like I can't say no to Marcina. I'm sorry. I'm saying no to the rest of you, though. Sorry. I am sorry.
Thank you, Julie. One of the things I'd like to ask is, because the scheduling was based on false information, known false information, since the scheduling was based on false information, and because it's been so detrimental to our country and to so many cultures, is there a way for us to do a class action against the government for making them illegal?
I mean, yeah.
Right. So, I mean, basically, the question is, how do we reschedule or deschedule, and can it be a class action suit?
Yeah, can we actually do a class action suit against the government for false information?
I'll just say this, the courts are really pretty conservative in the kinds of relief that they grant. You have to be actually harmed by the law to have something called standing. So you have to have been convicted and impacted by that law in order to have relief. And usually that's in the context of a criminal procedure. And so I'm not sure that there's wide availability for what you suggest. I'm sorry?
Well, it seems like we do with all the incarceration and all the issues that we've had, that there's been a lot of harm that we could prove.
So I guess the idea is that you would have to have the people who have been harmed, who have been had their civil liberties taken away to be part of the class action suit. Not just everyone, but like specific people who have been incarcerated or lost their liberties.
Yeah, I'm just going to say that I think there are probably a lot of procedural issues to that particular route, but in general, in order to reschedule, deschedule, to end the war on drugs, we need federal law to change. That will probably happen at some point, cynically, I'm sorry to say, after major lobbyists have convinced legislators how they want that to look and to make the regulatory system very, very Byzantine and complicated, and then we'll have federal legalization. I think that's probably what's going to happen in cannabis. And so for that reason, it's all the more important that we change laws on the state level, because then by the time federal decriminalization happens, there's so much happening on the state level, again, as we see in cannabis, that federal decriminalization will sort of be an adjunct to that.
All right, I want to thank both of our panelists, Graham Pechenik, Nicole Howell.